What's up? What's up? Waiting for a few people to get in here. I'm gonna be talking about a case around the self-defense. We got a few people in here. This is a case to come out of the D.C. Court of Appeals. But I had a conversation lately with a few people. What it do? I had a conversation with a few people recently that believe that there's no self-defense in the District of Columbia. But that is not actually true. V, what's up? So check this out right here, right? Singleton? Who is Singleton? Singleton. I might be thrown off. All right, but my bad. Here we go. So, a former Walter Reed pharmacist who in 2019 was found guilty of fatally shooting her husband in the back of the head was free from prison after the D.C. Court of Appeals overturned the conviction and determined that the judge overseeing her trial failed to adequately instruct jurors on the lingering effects of a particular legal defense, once referred to as battered wife syndrome. The Court of Appeals had granted Diana Lachan, 37 at the time, a new trial in 2013 for killing Christopher Lachan. But prosecutors earlier this month, and this article was written over a year ago, I just had to get to the article, so it wasn't this month, would end up dismissing all charges against her following the September ruling. Lachan, also known as Diana Lachan in several court filings, had served nearly half of her 7.5-year sentence in federal prison after the D.C. Superior Court jury in 2019 found her guilty of voluntary manslaughter while armed. The D.C. Court of Appeals ruled that Judge Rana L. Beck failed to thoroughly instruct jurors before deliberations about the lingering effects of spousal abuse and how those effects could lead to a person during an act of violence to believe they were acting in self-defense. The three-judge panel agreed that Lachan, public defender, and said Beck should have told jurors that they could consider the effects of battery in assessing whether Ms. Lachan's perception of danger was objectively reasonable. We are hopeful that the court's clarification of the district's self-defense laws will help reduce discrimination against people suffering from intimate partner violence who are forced to defend themselves against their partners, said Janet Mitchell, special counsel for the district's public defender service. The Court of Appeals decision was seen as a victory for individuals who claim self-defense in crimes involving domestic violence. But members of Christopher Lachan's family say they were robbed of justice by the appealing court and by the prosecutors who chose not to retry Ms. Lachan. In court, they made Chris out to be a stereotype, this big, angry, abusive black man. We know that's never what happened. That's what his family said. So a spokesman for the U.S. Attorney's Office declined to comment on that case. At the close of pre-sentencing, their evidence, Lachan's attorney asked Beck to instruct the jury in determining whether she acted in self-defense. The jury could also consider whether Lachan acted according to the opinion as a reasonable woman with a history of trauma and the effects of battery. That's an incorrect instruction. Beck wrongfully denied that request. The three-judge panel determined, concluding that evidence Lachan suffered from prior battery could be considered in determining whether she perceived danger, but had no bearing on whether her perception was objectively reasonable. Such an instruction, defense attorneys have argued, could help some jurors avoid faulting individuals who claim self-defense but then question why a defendant did not call police, seek a restraining order, or terminate the relationship. Attorneys have argued that many individuals who have been abused are often unable to make such rational moves due to being paralyzed with fear or frantically dependent upon the abuser, all of which, the attorney says, result in dismissed mental capacity. Patricia Riley, a former federal prosecutor in the district and now an adjunct professor at Georgetown Law, said the appellate court's opinion instructs D.C. judges to ensure such oral instructions inform jurors to consider that prior abuse can alter the rationale of a person who may believe he or she was in a violent situation. Hold on one second. Yeah, people have a hard time understanding the self-defense when it comes to abusive relationships, Riley said. They want to fault the abuse for not leaving the relationship or seeking help from police as soon as the abuse begins. But that would be irrational thinking for some people. The instruction would have reminded jurors that individuals have had years of abuse may not have been thinking rationally when they were assaulted or when they were killed, or when they did an assault or when they did kill. During the nearly month-long trial, Lachan took the witness stand, sobbing at times, and testified that her husband had been controlling and abusive. She said he often wrapped his hands around her throat in a fist of rage until she decided to fight back. Several of Lachan's co-workers and friends also testified, saying that they saw bruisings on her neck, and that she told them her husband had attacked her. Lachan told authorities on the night she shot her husband in their Southwest Washington home that the two had been arguing about getting a divorce, and he grabbed a mop handle and threatened her with it. It was then, she said, that she fired 3 bullets at her husband. The first 2 hitting the wall and the floor. The third bullet struck him in the back of his head. Federal prosecutor described Lachan as a manipulative and charged her with first-degree murder. Prosecutors argued that there was no evidence of domestic abuse and that Lachan had fabricated the story because she wanted to leave her husband and live a lesbian life. Prosecutors also said that she did not want to pay homage or shame her parents who raised her in a religiously strict household. Authorities said that there was no signs of struggle and no 911 call. Lachan pleaded for help before the shooting. Prosecutors argued that Lachan did not fit the profile of an abused spouse, an argument that defense vehemently countered with a based on stereotypes. The prosecutor stressed at trial that Lachan had an advanced degree and was the breadwinner of the household, making more than $100,000 at the pharmacy, suggesting she had the resources to leave the relationship. At trial, psychological experts hired by Lachan's attorneys testified that their client's behavior was consistent with that of other survivors of intimate partner violence, formerly known as battered woman syndrome, her attorney said. One of the psychologists testified that battered partners, both male and female, often do not leave an abusive relationship or report violence because of embarrassment or fear that such steps might make the abuse worse, or that they instead hope that the abuse will cease. Lachan's attorney argued that the psychologists have found that victims of abuse often are able to recognize verbal and nonverbal cues from their abusers as a flag of imminent physical assault. The attorneys requested that the judge overseeing the trial reiterate such claims by their psychologist to the jury. After 2 days of deliberation, the jury acquitted Lachan of first and second-degree murder, but jurors found her guilty of manslaughter while armed. As a guilty verdict was read, Lachan sat motionlessly. One of her attorneys was visibly distraught. Hold on one second, y'all. Yeah, my bad. I had something to take care of. All right, let me get right back to this. But I see some people keep asking about Fly. Fly said that Fly be back real soon. He got busy with some personal things. All right, back to this for those that is listening. In their appeal, Lachan's attorney argued. In their appeal, Lachan's attorneys argued that had the judge instructed the jury about the diminished capacity of abuse victims, their client would have been acquitted of all charges. Jeremy Carmel, another of Christopher Lachan's cousins, said it was outrageous that the case against their cousin's killer was dismissed. She shot him in the back of the head, and between 2013 and now, she only spent 3 years in prison for that. That is not justice, and now she lives her life. But Chris isn't so fortunate, Carmel said. So, I just wanted to get that off for real, because I was explaining to somebody about self-defense in D.C. Now, that's one, and a person could say that, okay, that case is special. Case is special, but my point is that the jury instruction is there. So, I'm going to find another one, but that one was up to date, and it was real. It was, on a legal tip, it was real, as they say, informative, because it had other aspects of law in there. Hey, bruh, I was trying to read your comments. They're a little erratic or manic a little bit. I don't understand what you mean. I'm gonna edit that one right there, just for the part about self-defense when I'm done. I never edited the live. I just be leaving them up there. Gotta be careful. Sometimes I be having information in them lives. Jimmy Wingate. Look up Jimmy Wingate, huh? Jimmy Wingate. Did he get the self-defense for DC, huh? Shout out to Northeast. Jimmy Wingate. I'm trying to find this other jump from the 90s where the jump outs jumped out upset for Taylor. Dude got the hitting. Police ain't have their jackets and their outer garments weren't marked with police. And he thought they was trying to rob. I don't know if that's what you talking about. Let me know though. I heard nothing but good things. That's what you talking about, huh? For real? His name was Jimmy Wingate? I can't even remember. I remember the case, and there's a couple cases like that. Well, I see they talking about the commanders on the news. I don't want to say the wrong word. Not on YouTube. Okay. I don't have no thoughts on the Knicks, brother. I'm not trying to be rude. I ain't a Knicks fan. I ain't a Knicks fan. I like to say I'm a Laker fan, but I'm really a LeBron James fan. I'm a bona fide Washington football fan. Salute, 1992. That sound about right, huh? Hey, Huck, we gotta do a live on YouTube, man. All right, but look, I'm gonna click this live off. LBJ, DC dudes. Hey, clap CH33KS. Okay, you made your comment. That's the comment you want to make. What do you expect in return? Because I'm about to get you out of here. You know, that's one thing about not having a whole bunch of people in here. I could do it myself. Boop, boop. Now, I normally don't do that. Like, if he had an honest question or an honest gripe, you know, cool. But you just want to keep making lewd comments. And I mean that word politely. I do mean lewd. But shout out to all the subscribers. Been tapping in, man. I appreciate the love, man. Y'all gave me the motivation to keep on rocking on YouTube. That'll be a classic collaboration. What you laughing at, Huck Sirs, man? We can get the followers up. And you know a rack of stuff. Interview is the Christ. I reach out to Edge. I ain't had no problem with that. I ain't got nothing against Edge. What kind of dog you got? I hear it walking around all the time. Every time I get on a thing, they get to running around. But that's just the house dog. That's a pit bull and a little teeny one. Other dudes trying to put that jacket on DC dudes. Bro, I don't even entertain that conversation. I could, and maybe one day I will, but I don't entertain that right there. Like, that ain't really no conversation of mine, and I don't understand how a whole bunch of people could have one stereotype and be interested in something that's just not their business. I don't do that. I don't do that. But if I had a feeling that the comment wasn't derogatory, maybe I would. But what's single? Other than that, who really cares? Shout out to my good New York man. Shout out to Tut. We was cool with Tut, man, on down Lee County. Shout out to Cheese. Shout out to Shannon Holmes. Wrote Be More Careful. Matter of fact, I got to hit Shannon. Matter of fact, I'm trying to hit him today. Oh, okay, my bad. Yeah, I used to rap, but I'm rap a young man sport, man. Unless you already in the game, like I don't want to be one of them dudes, Uncle MC or something like that. So I deal with YouTube. Nah, Let me click this just to make sure I don't mess this video up. And I'm gonna start it back. Don't go nowhere. Stay right here. We gonna do a question and answer and some other stuff. We gonna get interactive, man. Appreciate the love.